Hi everyone, Gene Richards here, attorney from the Williams Law Group, back on the Navigating DCP&P podcast, the podcast where we break down complex issues involving the Division of Child Protection and Permanency, or DCP&P. I want to remind you all listening out there that any information shared in this podcast does not create an attorney-client relationship, but we do welcome any person involved with the Child Welfare Agency, that being DCP&P, to contact our office for a confidential consultation with our team. On today's episode, we're going to discuss when substance use threatens custody. That's right. As you may imagine, substance use or substance abuse oftentimes triggers DCP&P involvement. Substance use raises concerns because it can directly impact a parent's ability to supervise, parent, and protect their child. Now, DCP&P isn't just looking for drug use in isolation. They're looking for how that use can affect parenting. Some common triggers for DCP&P involvement include a baby testing positive for substances at birth, an arrest or DUI charge that signals risky behavior, an overdose or emergency room visit, a call from a school, doctor, or even a relative worried about a parent's behavior. When substance abuse is identified, courts typically move quickly to put safety measures in place. Things like supervised visitation, or in serious cases, or even more serious cases, temporary removal of the children. But supervision and restrictions and restraints and removal isn't the end of the road. Courts expect parents to engage in treatment and show measurable progress, which might include substance abuse evaluations, inpatient or outpatient rehab programs, random drug and alcohol testing, counseling, or a 12-step program like an AA group. Now, these steps and these expectations and these ordered services can lead to restrictions being removed, a child being returned home. I do want to break down what these different services are, right? Substance abuse evaluation is done by what is deemed to be an expert, an assessor, who completes an evaluation to determine does an individual need recommendations for services, for treatment. Level 1, IOP, inpatient, outpatient, some sort of therapy. And at this evaluation, the first step is for the parent, the individual, to complete a drug screen. That person then will be interviewed by the assessor, asking about history of drug use and alcohol use, and then based on that history and that interview and that conversation and review of DCP&P records and what DCP&P tells the assessor, and the result of that screen, the assessor is going to recommend or write a report first, and in that report, recommend either there be no recommendations for treatment or what level of treatment is being recommended. And at that point, once that report comes in, it would be DCP&P's position that the parent then complies with those recommendations. Oftentimes, too, as a result of those recommendations, there may be further screens, random screens, most likely, or other things such as counseling, therapy, services that will help a parent stop doing what they are doing that's putting their child at risk of harm or harming their child. And when being ordered or recommended for services dealing with substance abuse issues, caseworkers at division and the judge want to see consistency. Missed appointments for your treatment provider, for therapy, missed screens or positive screens send the wrong message. On the other hand, regular attendance, open communication, and documented progress can show the court you're serious about recovery. One key point I do want to mention when you are in treatment, right? If you are a parent, because as I said before, sometimes people really do need the help. Someone struggles with alcohol or other illicit substances. And as your attorney, I want to make sure you get the help that you need to overcome that addiction and those concerns. And a big sticking point in many of these cases is the signing of releases. If you're in treatment, right, if you've had an evaluation or you yourself have decided to get the help you need and gotten into treatment, wherever that might be, the court is going to want to see documented proof of that progress. And in the orders, oftentimes it's ordered for a parent to sign a release for that facility, for that therapist, for wherever you're going to obtain treatment and services. And a lot of times parents say, I don't want to sign anything. I don't want to sign a release to have the division or anybody for that matter talk to uh, my inpatient facility or where I'm getting IOP. It's my business. Although I understand what you're saying, the court wants to see the proofs, the results of your screens. Here's from your counselor or your therapist or your provider for treatment that says you're complying and you're doing well, right? We can say these things, but documented proof is what the court wants to see. And without having releases signed to have that information obtained, the court may say, although I hear what you're saying, I want the documentation to prove what you are saying. Let me see the screen results. Let me see your therapist telling me how great you are doing in therapy. Let me see the person who's helping with your IOP say you're complying, you're engaging, you're attending each and every time, right? The court needs to see that consistent progress, that consistent sobriety. And the court, as we all understand that in these cases, there can be ups and downs. It's important to remember that if there is a relapse in cases like this, not to run away, not to ignore your attorney, not to hide, not to give up, but to face the concern, face the issue, and get the help that you need. I had a client who had a severe issue with drug use, and she was supervised. There was no removal, but she was supervised with her children, actually. And she was doing well. We were near having the case dismissed because she was doing so well in treatment with her sobriety, negative screens. At one point, she relapsed. She messed up. And I've had cases where clients who have done that have disappeared. I call them, they don't pick up, they don't email me back, they don't come to court, they don't talk to DCP&P, the worker, they don't do anything. But in this case, my client realized, all right, I messed up, get back on my feet, go back into treatment, get screened, get the help I need, and she got back on track right away. And the court, although didn't want to hear about the relapse, that's not what you want to hear in court as a judge. But the judge applauded my client for getting back on her feet and getting back on track. And as a result of her realizing, yes, I need the help, the case was able to proceed in the appropriate way where restrictions are taken away and DCP&P leaves the family and leaves her alone because she's doing well and the court dismisses the case. And that's the ultimate goal. Denying and saying there's no issues, if it's true, sure, let's say that. But if there are concerns, if you do have an issue with alcohol or drug use, you have to face that and you have to resolve that through services, through treatment, through screens, and even through an evaluation to figure out what level of treatment do I need. Now, as in every other situation with DCP&P in the court, the system is quite flawed, right? In terms of the evaluations and what DCP&P requests, unfortunately, whenever a call comes in alleging alcohol or drug use, DCP&P always asks the individual, well, we got a call about you being an alcoholic or using drugs. And because of that call, we want you to do an evaluation for substance abuse. And if you don't, we're going to court to have the court make you do one. Well, rewind right there, because first of all, the court does not always order what DCP&P wants a parent to do. And in many cases, I already kind of hit on the fact that, look, if there's an issue, a problem, you got to address it. But in many of my cases, false allegations are made where, an ex or somebody who does not like my client will call DCP&P, make a referral and say, this person drinks all the time and drove all intoxicated and smokes this and smokes that and while caring for my child or their child. And DCP&P gets involved. And of course, as I mentioned, they ask for, we want an evaluation, we want random screens. That's where I have to jump in and say, wait, context matters. In many cases, you have somebody making a false report that is completely inaccurate in an effort to get leverage in a custody case, in an effort to get back at the other parent. I have several cases right now where DCP&P is pushing for evaluations for substance abuse to try and get treatment in place. Now, in some of those cases, after providing context, at least already at this juncture, DCP&P realized, you know what? We should back up from our request because now that we have context from counsel, now that we hear both sides of the story, perhaps an evaluation isn't warranted. Unfortunately, some of those cases are still battling it out. We haven't been to court for most of these cases thus far, but we're trying to figure out a way to avoid court without giving DCP&P really anything they want because these allegations just aren't true. And so unfortunately, whenever DCPP has a call, they tend to believe what the calls are saying. You always hear in criminal court how someone is innocent until proven guilty. With DCP&P, it feels like the opposite, right? So we have to show the division or court, if DCP&P files a complaint regarding these evaluations or this treatment, that the context here suggests that the referral and the allegations are completely untrue. And here's why. Another flawed part of this process is that once a client submits to a substance abuse evaluation, you're pretty much stuck with what's recommended. And I'll explain what I mean by that. A lot of times clients come to us or come to me after they've already engaged in a substance abuse evaluation. And they tell me, I don't want to comply with this. This person is a hired hand by DCP&P, right? These people, this facility, a lot of times preferred behavioral health or different facilities, Catholic charities, different facilities who DCP&P utilize and make referrals to have them conduct these substance abuse evaluations. It's like a referral source, essentially. These places, they work hand in hand with DCP&P. And so I feel like this person was biased and made a recommendation that's not warranted, not what it should be. And once you submit to an evaluation, or any kind of evaluation, but talking today about substance abuse evaluations, that recommendation you're stuck with, unless there's options. You can get a second opinion, right? Perhaps you want to go somewhere else and have somebody else evaluate you, and that person may say you don't need treatment, or a lower level of treatment is necessary in this case. That's an option. But even so, at that point, you have their expert versus your expert, and you'll probably have to battle that out in court. And so once you already submit to DCP&P's request for a substance abuse evaluation, you're putting yourself in a tough position to really push back and say, I'm not doing anything else, unless the evaluation comes back as clean and clear and there are no recommendations. So it's important to really reach out to counsel before doing anything, because when you obtain counsel and you're already on step 2, 3, 4, 5 in a case, your attorney has to kind of either try and fix what already has happened, fix the mess, or get the case back on track. Now, no point is too late to hire counsel, but I'm just saying that oftentimes a client says, I don't want to do something, and you've already done it. And then in doing that evaluation, your recommendations you then are recommended to do. And unless you find someone who says that's just not accurate, or I'm an expert and I disagree, court's going to rubber stamp those recommendations. Unless that evaluator is so unprepared or not credentialed to do an evaluation, which typically people that are there, they've done 1,000 of these. A court's going to say, well, you did the evaluation, and this person who does these things every day says you should do a service. I'm ordering you to do that service now. It's important to try, and if you're going to push back, you want to push back prior to even doing the evaluation, because as I said before, oftentimes the evaluations should not even have to happen. Another flawed part of this process is that, here's the thing, this evaluator, they make recommendations. It's up to them. Now, you may say, I haven't had a drink of alcohol in my entire life, or I haven't done anything wrong in my entire life with substances, and you may have a negative screen. But that evaluator may say, well, I'm reading between the lines, and I think this person is not being forthright or being honest. And so I can't control, nor can you control, what an evaluator says about you. That person has their individual opinion. And so once you submit to an evaluation, you put your case, your recommendations, your services potentially in that person's hands, which is why if you can avoid evaluations, especially substance abuse evaluations, you should do that. And so that's why it's important to push back and give context to the division, as to why, for me to agree to an evaluation, should not be happening. And here's why. Dad or mom are upset. They lost the case in family court, and they've lost parenting time. So they're getting back at me now by making up false allegations. It happens all the time. Unfortunately, it truly does. And so we have a reputation in these cases to push back with, because look, DCP&P knows that, from what I gather with DAGs and people that work for DCP&P that I work against on cases, when we get involved, right, they tend to step back. I've had so many cases where DCP&P requests evaluations or screens, and when we just send them a letter saying, hey, we're the attorney on the case, they tend to second guess what they requested and back away. I had cases where a client was told by the worker, you got to do more screens. We're concerned about your use of substances. I call the division, send a letter of representation, tell them the context. My client has been sober for 3 years now. She had an issue three years ago or more. This is, Dad, upset he lost a case in family court, upset that my client filed for a restraining order against him. And as soon as she did those things, he called DCP&P. And upon providing their attorney with context, DCP&P's attorney with context, DCP&P's worker did not ask for a screen, and the case was dismissed, I want to say, a week or two after. And so we have a reputation that when we make a position, because we're reasonable, right? If a client needs help, I'm going to tell you need help. If a client's being accused incorrectly by a bitter ex, I'll tell DCP&P what's happening. But right, when we give positions and have conversations with the division, right, they know our position is either strong or true, or we're not backing down from it. And so it's important to really assess where you are as a parent. Do I need the help or do I not? Because if you need the help and don't get it, your case is not going to go well. If you need the help and get it, it will go well. If you don't need the help and it's a false allegation, then also it will go well. But if you do need help and are getting it, an attorney can only do so much, right? If you're testing positive on screens or not doing treatment you're required to do, your case is not going to go forward. It's going to either go backwards or remain stagnant. So it's important as an individual, as a parent, as whatever role you play in a child's life, to get the help you need if you need it. I just want to thank you all for, once again, listening to the podcast and remembering what DCP&P cases involve substance abuse and how that can impact custody and how that can impact you as a parent and what services might be in play and when to fight back, when to agree to something. These are all things you must weigh in your case. And so I want to ask you all as listeners to subscribe and share our podcast to your family and friends. And if you or your loved ones or someone else you know needs services or support, we have our website. We can call our office for a consultation if need be. Just to preface our episode for next week, we're going to get into why some kids don't go home.